there have been many high-profile cases which are demonstrating the impact that the Me Too movement is having both in the workplace and outside of the workplace. And we don't even need to stretch our minds down to our friends in the South. There are some homegrown cases, thinking of Jean Ghomeshi and CBC, Patrick Brown and the Conservatives, and Albert Schultz and Soulpepper. There is definitely lots of chatter and talk about how the Me Too movement is either affecting reputational risk or impacting the workplace in terms of the impact that it would have for any sort of cases that a judge might award damages for. So today I'm going to be talking about the Me Too movement and the workplace. I'm going to be talking about, I'm going to focus on investigations and why they're important and how I see them as being integral to the Me Too movement. And then /tag, what shouldn't you do in terms of your workplace and investigations. And just the /tag comment clearly shows that I did not write this, so before I go any further, thank you to Lucy for having made me look smart on this, and I don't use hashtag. Okay, so we talked about reputational risk. These cases demonstrate monetary risk that you have as well, because what we're seeing is even before the movement took on a big profile, that there, of course, the cases demonstrated a willingness on the part of both the court in Walmart, an arbitrator in the city of Calgary, and the Human Rights Tribunal in Singer to award damages where harassment has been established. And I don't need to go into the details of any of those. They're pretty well known. I would say about the Singer decision, though, it's a perfect example of, in this case, a vice chair going out of his way to award an award that would not necessarily be within the box of what they were entitled to. In that case, the $200,000 general damages award was probably at the highest end, so as high as he could go. But he took that one step further by awarding a decade worth of interest. And that was, I think, his way of demonstrating the fact that in this case, the tribunal was going to go out of their way to penalize, in this case, Mr. Singer for his damage to this individual that had gone on for over 10 years. So what does this, and before I go on any further, I wanted to mention in terms of the court cases that last week a decision had been rendered whereby an individual was granted intervenor status in a wrongful dismissal case. The individual who was bringing the wrongful dismissal case had harassed her. There had been an investigation. There was a finding of harassment, and his employment has been terminated. He's now bringing a wrongful dismissal case, and the individual whom he harassed, was granted intervenor status. So that is going to be another thing that as employers you're going to see in the workplace in terms of understanding how that intervenor now is going to impact or be involved in your action that you typically would have control over. So what we're seeing now is a general understanding or impact in the workplace in terms of expectations. So as employees, as board members, as stakeholders in your workplace, people have expectations. And so in 2017, 30% of employees reported experiencing workplace harassment. Also in 2017, 63% of men and 77% of women believed that harassers didn't face any consequences for their actions. In 2018, 40% of HR professionals are stating that their organizations take a reactive versus a proactive approach. And also in 2018, 53% of board members are saying that they're taking a more active role in wanting to review policies. So in terms of thinking about stakeholders in the workplace, you're now having a greater demand, a greater impact, a greater scrutiny over the steps being taken in respect of harassment. So what's the result? We talked about this kind of greater scrutiny and an increased awareness, lots of water cooler talk. You also have, there is a bit of a backlash, I would say. We hear some employers saying that male mentors are uncomfortable with taking female mentees out for lunch out for client events for fear that they may cross the line. They're being very controlled in terms of their relationships with their female mentees because of this increased awareness and because of the discussion around the Me Too movement. And most importantly, for your perspective, or what you're here to talk about, is there are more complaints. And more complaints equal more investigations. And what the case law is demonstrating is that a good investigation can make or break your situation. It also, a good investigation helps manage the issue in the workplace and helps manage the repercussions of any investigation. So I thought we would focus on that today. We would focus on what constitutes a good investigation, why a good investigation is important, and go through some of the factors that we're seeing in both our advisory practice and in the case law. So just so we're all on the same page, the obligation to investigate arises statutorily under the OHSA, under the Human Rights Code. It also arises at common law. And most cases, all of that is going to be encompassed in your policy. And I will say the policy is the best tool that you have. So for those of you who don't conduct investigations regularly, it might be a good opportunity to go through it and make sure that it's still going to fit in this environment. And when I say fit, I mean it should be used as a tool. It's going to set the parameters, it's going to set the expectations, it's going to tell the individual what to expect at the end of the investigation so that everyone is on the same page. And if you are conducting the investigator or an external person is conducting the investigation, everyone knows what to expect. So, does your policy encompass all the legislative requirements? When the OHSA was initially amended to include violence and harassment, there was lots of discussion about whether or not we have a separate policy that would fall under health and safety, or whether we would make an omnibus policy that would incorporate everything. Most employers, I think, have erred on the side of the omnibus policy that includes everything. And I know some people decided not to, the reason being that they were worried about how involved the Joint Health and Safety Committee would have to be. But I think what we've seen and what the case law has shown us and what the Ministry of Labor is telling us is that the Joint Health and Safety Committee does not need to take a role in a harassment investigation. We'll talk a little bit about when they get involved, but from that perspective, I think the omnibus bill still works for everybody. What's your reporting structure like? So in the Schultz example, there was only one person to report to at Soulpepper. So if you had a harassment complaint, you were going to an individual who turned out to be the wife of the person who they were alleging harassed him. So look at your reporting structure. Does it have other alternatives that that person could go to? Review your process. So if you've recently done an investigation, I think of a policy as being a bit like a living tree. It's not supposed to stay the same all the time. You use it a couple of times, it may not work properly, so you may want to think about changes that you can make to it. Do you require a written complaint? As an investigator, I love a written complaint because it sets the box. It sets the parameters. I understand under what parameters I'm investigating. The individual complaining understands what we're investigating, and it allows you to control and focus the investigation a little bit. Have you committed to a period by which to complete the investigation? The OHSA provides a guideline of 90 days that you can go further if it requires lots of witnesses or is particularly accommodating in terms of individuals who require accommodation. So do you have a timeline? I have a client who has a 10-day timeline. Every time I conduct an investigation, I have to get a waiver of consent from the individual saying, we will not finish this investigation in 10 days. What is your obligation to inform the parties? We'll talk a little bit about when we talk about pitfalls, but there are definitely requirements under the OHSA in respect of responding to a harassment and the form that it should take. And then, as we said, what obligations do we have to the Joint Health and Safety Committee? I would say that because of the overall arching mandate of the OHSA, which is to report any hazards to the Joint Health and Safety Committee, if you have an individual who's had multiple complaints against him, I would suggest that that becomes a hazard. And you need to think about how you inform the committee of the fact that there's this hazard. Keeping in mind that in most cases, for those of you who report to a board, your Joint Health and Safety Committee minutes are now going up to the board as well, because from a due diligence perspective, they want to see what's going on. Okay, so thinking about kind of the questions that we get, the things that I see when I investigate, the conversations I've had with my group, and the case law, we've come up with a couple of situations where we, or highlights that we want to give you in terms of things to consider when you're investigating. The biggest one we hear all the time is, do I need to investigate this? And we'll talk about the tip line and the person coming to vent, but the reality is that knowledge is sufficient. If you have knowledge, if a manager has knowledge, it's now knowledge of a complaint that needs to be investigated. And the failure to investigate can attract liability. So in the case of Morgan, the tribunal in fact found there was no discrimination. But notwithstanding the fact that there was no discrimination, because the employer had failed to investigate, the individual was awarded damages. So the failure to investigate can attract liability even where you haven't done anything wrong. My favorite, I'm just coming to vent. I don't want you to do anything about it. I just need somebody to talk to. That person needs to understand you have an obligation. So although you can temper that, and this is where I don't wear an HR hat, you can temper that with wanting to provide some coaching and figuring out what to do. You need to understand that in the end, it is your responsibility to decide whether or not this needs to go to an investigation. From a hotline perspective, where you get an anonymous tip, that one's very difficult. And you'll see that happen in National Bank, where they received results as a result of an employee survey that clearly demonstrated, according to the employees who filled out the survey, that this individual had an issue with respect to being a supervisor and how he was treating members of his team. And so instead of conducting an investigation into it, because in their view, they already had the evidence from the survey, they decided to demote him, take away his supervisory responsibilities. And in the end, they may have gotten to the same conclusion if they'd only taken the steps to actually go and interview. And that doesn't mean speaking to everybody. That means taking a snapshot or a couple of specific individuals that you know probably have the ear to the ground, and speaking to them and understanding what that means, and then going to the supervisor and presenting that evidence. Once you've concluded all of that, they may have come to the same conclusion, but at least they would have covered themselves off in conducting that investigation. Whether you do external or internal investigations, this is really, there's no bright line test. It is a case-by-case analysis. You need to understand who's complaining, how sensitive it is, cost, and understanding whether or not you want to go externally. Also, from a competent person or a competent investigator perspective, if there's someone in your workplace who doesn't have that skill set to be able to do it, you definitely need to go externally, because the Ministry of Labor will not look kindly on that. It used to be in the old days that we would want the document to be privileged. So you would hire externally so that the investigation would be privileged. The reality is, with the focus on investigations, we're not cloaking the investigation in privilege anymore. So whether you use counsel or a third party, it doesn't really matter, because we're not going to do, we wouldn't recommend keeping it privileged. The only time we would do that is after litigation has already commenced. And then in that case, it doesn't matter what the investigation reveals. All it does is you understand what your liability is, and that's the purpose of the investigation, not to fix the issue, since that person has already commenced a claim. And that was the case in home hardware. The snowball effect. You speak to one person who says you should speak to somebody else, who says you should speak to somebody else, and all of a sudden, if you don't have a written complaint where you've set out the four corners of your investigation, you're now into 6 million different issues, and now everyone's complaining about other supervisors. So the snowball effect can be limited by getting a written complaint and limiting what it is that you're discussing. It also is, when I conduct investigations, I let the individuals, both the harasser and the harassee, understand that notwithstanding the fact that I'm welcoming them to provide me with witnesses that they think I should speak to, I control the investigation. I pick and choose who I'm going to interview, and I may or may not include those. And so the expectation up front, because you know they've gone to their friends, notwithstanding the fact that you've told them to keep it confidential. You know they've gone to their friends to say, I've raised a complaint, you're going to be spoken to. And when I don't speak to that person, then all of a sudden I haven't done a proper investigation. So understanding up front that that's the rule of the game, and I put that in a letter to the individuals, really helps control that snowball effect. You want to think about whether you need to go outside the workplace. With so much of what we do and our workforce not necessarily being in one environment anymore, you sometimes need to go outside of the workplace in order to get evidence. You want to think about how you're going to do that and how you're going to protect that information if you have to go to a bartender, for instance, who's going to be your witness. You'd be surprised at the places I've gone to interview. And then, I know it sounds trite, you have to interview all named parties. So even though it's uncomfortable to be interviewing the CEO who might be your boss, you have to interview all named parties. Confidentiality. This goes a little bit with the snowball effect, because the snowball effect and confidentiality means that everyone's talking about it. Notwithstanding the fact that you told everyone to keep it confidential, everyone's talking about it. So a tip that I use is when I'm sending out those letters, I send letters out to witnesses as well. I'm going to meet you on this date. I'm investigating under, and this is the guise of what I'm investigating under, the OHSA, the Human Rights Code, and your policy. I'm going to ask you to participate on this date. I'm going to remind you to keep everything confidential. The fact that I'm interviewing, the fact that you're coming to an interview, the fact that there's a complaint, what we say in that meeting is all going to be kept confidential. And if you breach it, they are grounds to terminate your employment for cause. Nothing like a little bit of a threat to try and keep that snowball effect a little bit contained. The one thing that we've come up recently, and the client is actually in the room for which we did this, was a release where the individual said, I'm part of the Me Too movement. You may not agree with the fact that I was harassed, and I'm going to leave notwithstanding, and I'm going to sign this release that says I'm not getting anything. But can you let me at least share my experiences with people? So we hemmed and hawed over that, and it's become common practice to allow them to speak of the fact that they've been a victim of harassment without breaching the confidentiality provisions. It's clear that they can't refer back to their employer, that they can't use specifics that would allow the employer to be recognized, notwithstanding the fact that you can go on LinkedIn and see the last 3 employers they had. But at least that got us where we needed to go in terms of getting a settlement. And the reality of the situation is they were likely going to talk about it anyway. So at least you've set parameters around it. So something to think about, or at least be prepared for when you get asked. Evidence. Witness statements I find very, very helpful, especially if the witness signs them. So if you have the ability, sometimes it's not a function of the reality of the world we live in and how quickly these need to be done, but allowing witnesses to sign statements after you've met with them is very helpful in terms of ensuring that there's no contradiction later. I never disclose my witness statements, so the report that I give to a client never identifies the individual, never provides them with the witness statements. They only stay in my file. But that allows me the opportunity, if ever I get challenged, to say, this is exactly what you told me, and here's the line that you signed and agreed to. Forensics, as HR people and as HR lawyers, we are sadly lacking in tools for forensic because it's not within our bailiwick. So I've actually done a bit of training now to understand what forensics are available to you and how easily it is to get them. Now, you do have to get IT on side, especially if it's a confidential investigation, and you need to train your IT people on how to produce evidence properly in terms of mirroring it, ensuring that there's no tampering of the evidence so that if ever we have to use it, the chain of evidence is clean. But once you get past that initial hurdle, which is really easy to get past, it's a great tool to use. because there's nothing better than two employees saying that their manager is horrible to them, and then going back to a Snapchat discussion and seeing that, in fact, they've arranged all of this to get rid of their supervisor because he's way stricter than the other supervisors in the company. So from that perspective, it's a good tool to keep in your back pocket as an HR person or as an investigator. And then the smoking gun. It's sometimes a strategy that people use to keep the smoking gun and not disclose it, because that's proof of the fact that they were lying. So in the Loretti marketplace is a perfect example. The individual is 18 years old. She put something on Snapchat, and in the background was the company. She said something negative. Her mother made her take it down on the same day. She completely forgot about it. 2 weeks later, she's in an investigation, and they asked her whether or not she had put anything negative about the company on social media. She had completely forgotten about it already and said no. And they never presented it to her, because if they had presented it to her, it probably would have triggered the memory, and she would have realized, and she could have given a reasonable explanation as to why it was that she didn't remember it. And so the arbitrator in that case reinstated her, because again, the smoking gun is only as good as the fact that you're presenting it to the individual and getting the explanation. It's the explanation that's a smoking gun, not necessarily, in this case, the Snapchat. Confidentiality, going back to my great little letter that I love, we do want to keep, we already talked about this, documentary requirements. Going back to my letter, the letter to the complainant will say, and your policy should say, once we've concluded our investigation in a reasonable period of time, we will report back to you. And so we're reporting back to you very specific things. Again, they're not getting the full report. Even if they have counsel, they're not getting the full report. They're getting a summary of the report that sets out the allegations, the summary of the findings, and the corrective action. And I only limit the corrective action to the individual themselves. So they don't necessarily know, although I might put it in vague terms that if the findings were substantiated, that the individual she complained about is also receiving corrective action. I never tell them exactly what's happening with them. So from that perspective, it's a good way of, one, abiding by your obligations under the OHSA. So if the Ministry of Labor ever comes in and says, I hear from an employee that there's been an investigation, I'd like to see the investigation, they have the ability to review the investigation, to set out whether or not, in fact, you've complied with the legislation, whether you're competent to have conducted the investigation to begin with, and whether or not they're going to require you to go to an external and redo the investigation. So this allows you at least a paper trail to show the Ministry of Labor. But I also like it from the perspective of, it follows your policy, it follows the original letter that you sent out, setting out the expectations in terms of what they're going to get. And they feel like they've gotten something to substantiate whether there was a finding or not finding. And it's never a black and white. It's never a scenario where you're going to substantiate all the allegations, but that'll allow you to kind of tell them why you're only substantiating in part based on the summary of findings that you're providing. And again, you would never produce the full report. The only ever time you do it is if you're required by law, or if for public reasons you do so. How many of you read Janice Rubin's report on Jian Ghomeshi? I know I did, back to front, back to cover, or cover to back, or whatever that's called. Because that was a smart idea on their part. They put out the full report, full disclosure. We're a public entity. We want you to see we want you to know what we know. And here's the report. In the University of Waterloo case, again, a public entity with public stakeholders and a reputation to uphold, they disclosed the findings, the decision, and the rationale for the decision. They may not have disclosed, and in fact did not disclose the full report, but they provided enough information that that as a public stakeholder, I could decide whether they were right in terms of their investigation. So another thing to think about. So all to say that the Me Too movement is providing, this was not a very legalistic talk. The purpose of this talk today was to talk a little bit about the impact that it's having in the workplace and in terms of what you're going to see day in and day out. Give you some tools in terms of understanding how it is that you can use investigations as a way to monitor the situation, as a way of ensuring that our workforce is in compliance, and perhaps as a way of defeating what I think is the biggest impact, which is this backlash that men are uncomfortable mentoring female mentees and allowing that kind of comfort level to come back to what it was at one point. Thank you.